Hello everyone, my name is Geetanjali Sharma and I am a graduate of Cambridge University, having specialized in international economic laws and dispute settlement. I am here before you to present the module on state trading enterprises. As we begin, I would like to provide a brief structure to the module. First, we shall be dealing with the meaning and types of state trading enterprises as have been discussed within the framework of the World Trade Organization. Second, we will be addressing the issue of why there is a need to regulate the state trading enterprises. Third, we shall delve into the WTO's discipline in the regulation of state trading enterprises and also explain vital provisions pertaining to the exclusive or special privileges held by the enterprises, the commercial considerations involved, and other consistent obligations to be abided by the state trading enterprises with respect to principles such as non-discrimination. Thereafter, the fourth aspect of the module would deal with several obligations of the state trading enterprises pertaining to non-discrimination, non-quantitative restrictions, and preservation of value of tariff concessions along with transparency. In the end, we shall address the ongoing academic debate on the question of the rules of state trading enterprises and whether they apply to enterprises as such or countries as a whole. Having given the brief overview of the topics that we would be covering in the course of this presentation, I would now like to move with the first aspect dealing with the meaning and types of state trading enterprises. I would draw the attention of the listeners to Article 17(1)(a) of the GATT agreement and to read out the meaning of state trading enterprises as have been discussed entail. The meaning of STEs include state trading enterprises owned by the state. STEs also refer to private enterprises that are granted special privileges by the state. The nature of the special privilege should be such that it provides advantage to the enterprise vis-a-vis other entities, and as a result of this special privilege, the enterprise is in a position to influence the level or direction of trade. Further, examples of this privilege have been described in the agreement, and they include to mean subsidy or equivalent, monopoly status in the production, consumption or trade of goods. It is further important to note that the special right or privilege granted need not give the enterprise a monopoly position in all situations. Therefore, a reading of this clause highlights various relevant aspects in the meaning and concept of STEs that must be understood. First, it must be noted that state trading enterprises are owned by the state. In certain cases, they may also refer to private enterprises that are granted special privileges by the state. Now, the nature and inquiry of this special privilege is a legal issue, and in the course of presentation, I shall further elaborate on this point. But for now, it means that the privilege should be sufficient enough and advantageous enough that sets out the enterprise vis-a-vis the other enterprise in a position to influence its monopoly in the market and control the direction of trade. However, it is not obligatory on the part of the enterprise to have assumed a monopoly status, and therefore the threshold of special privilege is that of dominance and not monopoly. Furthermore, examples of this privilege have been said to be subsidy or status such as a monopoly status or any equivalent of such advantage or privilege. A classic example of what may be classified as a state trading enterprise could be drawn from the Korea beef case, where the Livestock Products Marketing Organization, LPMO, which was established to administer Korea's import restrictions on beef, was classified as a state trading enterprise. Now we move on to discuss the types of state trading enterprises. There is a brief mention in legal commentaries that there could be several types of state trading enterprises, and their nature could be in the following manners: statutory marketing board, export marketing boards, regulatory marketing boards, fiscal monopolies, canalizing agencies, foreign trade enterprises, or boards or corporations that have resulted from nationalized industries. Therefore, so far we have discussed the nature and meaning and types of state trading enterprises. Now we move on to the second aspect of the module, which deals with the need as to why state trading enterprises ought to be regulated. First, we note that the state trading enterprises require regulation because they could potentially become disguised tools for conducting several forms of violations of either market access or tariff commitments or export subsidy discipline. One may note that state trading enterprises may also become vehicles for unintentional distortion of trade. For example, if a monopoly on alcohol is maintained in order to protect public health and certain institutions are formulated in that regard, that could potentially involve several breaches of tariff commitments and market access regulations that states have adhered to in the GATT agreement. Even though it is justified to have state mechanism and agencies to protect public health and maintain such regulatory bodies in the name of state trading enterprises, it cannot be ignored that these vehicles may become tools for disguised protectionism. Similarly, there is a need that is felt where state trading enterprises ought to be made to behave like competitive players in the market, and therefore a need for a regulatory framework is invoked. Having discussed this aspect, we shall now move on to the actual discipline within the WTO and how it deals with the regulation of state trading enterprises. The relevant article under the GATT agreement is Article 17, Clause 1, which sets out the discipline for the regulation of state trading enterprises. Article 17(1) indicates that each contracting state undertakes that it establishes or maintains a state enterprise wherever located or grants to any enterprise, formally or in effect, exclusive or special privilege. Such an enterprise shall, in its purchase involving either import or export, act in a manner consistent with the general principles of non-discriminatory treatment, which has been prescribed in the agreement for certain governmental measures affecting imports or exports. Therefore, the key word is that when the STEs, which have been granted exclusive or special privilege, are acting in a manner where they are dealing with import and export, they ought to adhere to the principle of non-discrimination. Further on, it is governed by Article 17 that such state trading enterprises, having due regard to other provisions of the agreement, must make the purchase in accordance with commercial considerations. Therefore, apart from the national non-discriminatory obligation that have been imposed on the STEs, there is also an obligation to take due regard to other provisions of this agreement and specially conform to commercial considerations. Now, the clause further goes on to define what the commercial considerations are, and they include within its purview price, quality, availability, marketing, transportation, and other conditions of purchase or sale, and shall afford the enterprise of other contracting parties an adequate opportunity in accordance with the customary business practice to compete for such participation in the purchase or sales. Therefore, the meaning of commercial consideration must take into account customary business practice in dealing with various aspects of trade transaction. Now, we move on to discuss the core aspects of regulation as have been entailed in Article 17 of the GATT agreement. First, we look into the concept of exclusive or special privilege. As have been discussed before, the nature of exclusive or special privilege is such that it provides an advantageous position to an enterprise. As reiterated, the position may be that of a dominance and not absolute monopoly. In the Geneva session on the preparatory committee, while this issue was being discussed, it was stated that government measures that impose standards on quality and efficiency in the execution of external trade and certain tax exemptions do not constitute exclusive or special privilege. This clarification, as drawn from the text of preparatory materials, also become relevant in dealing with the definition of exclusive or special privilege. Second, the meaning of involving either imports or exports, which is the second aspect in the definition going back to Article 17 of the GATT agreement dealing with state trading enterprises. Here we look into the aspect of the control of an enterprise and its ability to influence the imports or exports, and this may become the second issue of inquiry within the meaning of Article 17. Now, the act in a manner in which these enterprises must adhere to the principle of non-discriminatory treatment also becomes relevant. The aspect of commercial considerations and how it usually takes the same price as would exist in the different markets is also important in discussing the contours of Article 17. One important aspect to be described here is that even though commercial consideration must be based on customary business practice and must ensure that the same price is maintained across different markets, some leeway has been provided to the countries to charge different prices for its sales for a particular product in different markets, provided that this is done with certain commercial reasons in mind to meet conditions of supply and demand in export markets. Here, the legal analysis involves within its purview a bit of competition element in it, as competition laws indicate that the pricing across different markets is done based on different levels of demand and supply and the substitutability of a particular product in the market, which go on to determine and influence the price. Therefore, while the law under the WTO regime, specifically Article 17, which is being discussed here, imposes the obligation of commercial consideration, which normally means equality of prices. It also provides the leeway to charge differential pricing as long as there is an economic rationale behind it, which may also become legally justified. Further, we move on to discuss the aspect of non-discrimination and the nature of obligation that is imposed upon the state trading enterprises. Here we look at the 1952 WTO panel report on Belgian family allowances, where it was resolved that the obligation of a state trading enterprise to make purchase is in accordance with commercial considerations, and it does not extend to matters dealt with under Article 3 of the GATT agreement dealing with national treatment provision. Therefore, under the law of STE, it is now resolved that the articles on state trading enterprises refer only to the most favored nation treatment obligation of non-discrimination and not to the national treatment obligation. This issue of non-discrimination and its nature and scope also becomes legally relevant in the analysis of Article 17. Next, we move on to the second aspect of Article 17, specifically Clause B, which deals with providing due regard to other provisions of this agreement. As stated before, apart from the non-discriminatory obligation that have been imposed on the members, must also give due regard to other provisions of this agreement, And this phrase has meant to mean differential customs treatment which have been maintained consistently with other provisions of the Charter. Therefore, apart from the non-discriminatory obligation, we are also dealing with differential custom treatment and such provisions as have been made applicable to these trade trading enterprises. Now, we move on to the last bit on commercial considerations and how it interplays with the state trading enterprises. It is discussed that commercial considerations criteria become relevant only after it has been determined that the government action at issue falls within the scope of the general principles of non-discriminatory treatment prescribed by the GATT. Therefore, that is the second test that steps in after the non-discriminatory treatment issue has been resolved, and the panel or the appellate body will now analyze the issue of commercial consideration. Now, moving on to the discussion of special provisions that exist for the developing countries. In the discourse of state trading enterprises, the developed country members are to make every effort in cases where a government determines the resale price of products wholly or mainly produced in the territories of developing country members in order to maintain that trade margins exist at equitable levels. Therefore, there are adequate provisions that take into account special privileges that must be conferred for developing country members and the products being manufactured in those territories, based upon which the resale pricing of products would be done by the state trading enterprises. Having discussed the nature and scope of Article 17 of the GATT and the meaning of various technical terms involved in the article, we shall now move on to discuss the substantive obligations of state trading enterprises. The first obligation deals with the concept of non-discrimination, which is commonly referred to as the most favored nation treatment. The concept of non-discrimination takes different shape and meaning across different provisions and agreements of GATT and other WTO covered agreements. Therefore, the technical meaning of non-discrimination in each of the agreement and clauses becomes very relevant. Here, as has been discussed before, when we talk about non-discrimination, we are specifically putting our focus on the MFN or the most favored nation treatment obligation and not the national treatment obligation. Therefore, one can say that a state trading enterprises obligation in this regard is only limited to MFN. Now, members must undertake that any enterprise covered by Article 17(1)(a) shall in its purchase or sales involving imports or export must act in a manner which is consistent with the general principles of non-discrimination as have been set out in the General Agreement of Governmental Measures Affecting Imports and Exports by Private Traders. Further, the non-discrimination clause also gets interlinked to the commercial consideration clause as has been defined in terms of pricing, quality, availability, marketability, transportation and other conditions of purchase and sale. Further on, in purchase, sales and other export provided by private traders, differential pricing is permissible as long as there is a commercial reason behind it, as has already been discussed before. And further on, the rights of private players should not be prohibited in the exercise of monopoly status. Therefore, non-discrimination obligation, even though provides certain restrictions on the operation of these state trading enterprises, it never should affect the rights of private players to exercise monopoly status. Now, second, it should be noted that a strict MFN or a most favored nation treatment was never envisaged to be applied in the context of state trading enterprises. This has further been clarified in the interpretative note to Article 17, Clause 1. The note allows that a state trading enterprise can charge different prices for its sales of a product in and across different markets, provided that it is done for commercial reasons to meet the conditions of supply and demand in the export market. Therefore, the issue of non-discrimination and commercial consideration again gets interwoven when one is describing the nature and extent of non-discrimination obligation as is imposed on these state trading enterprises. Thirdly, we move on to discuss another manifestation of non-discrimination as is being imposed on the state trading enterprises. Now, this manifestation is derived from the relationship between Article 17 and Article 20 Clause D of the GATT Agreement. Article 20 of GATT Agreement deals with general exceptions, and Clause D of Article 20 deals with public laws and other measures taken by the states. Now, pursuant to this, a country has a right necessary to secure compliance with laws which are consistent with the general agreement which relate to the enforcement of monopolies. Therefore, in securing its rights under Article 20D of the GATT Agreement, members have the right to enforce by virtue of law certain monopolies and the existence of state trading enterprises. Now, this right is specifically provided for in Article 20 of the GATT, and further on, the panel report in Canada Import, Distribution and Sale of Certain Alcoholic Drinks recognized as following. The case recognized that a beer import monopoly that also enjoyed a sales monopoly should not prohibit unconditionally the private delivery of imported beer while it is permitting the entry of domestic beer. Here, in this case, Canada's right to establish the import and sales monopoly for beer did not entail the right to discriminate against the imported beer, which inconsistently would affect Article 3, Clause 4 of the GATT Agreement pertaining to national treatment, though regulations affecting its internal transportation may be affected in this regard. Therefore, a clear demarcation has been made with respect to member countries' rights to secure and enforce state trading enterprises and conduct transactions through these state trading enterprises, which is a recognized principle even derived from Article 20D of the GATT. However, the same could not be stretched to violate other provisions of GATT, especially the non-discrimination bit. Now, we move on to discuss the other obligations of state trading enterprises as have been entailed under Article 17. The second obligation entails that a law which granted a state trading enterprise an exclusive import right in a certain product and a decision by that enterprise to refuse to import the product at all would appear to be a violation of Article 11 of GATT, which deals with general elimination of quantitative restrictions. Therefore, the obligation of quantitative restriction, as the discourse of which is elaborated in Article 11, also continues to apply in the operation of the state trading enterprises. Now, we move on to discuss the aspect on the preservation of the value of tariff concessions and how this obligation is related to state trading enterprises. Within this concept, any monopoly of the importation of any product covered in a GATT schedule shall not result in protection which is on the average and in excess of the amount of protection provided for in that schedule. Therefore, the law on preservation of value of tariff concessions is made to prevent any import monopoly from instituting protection for the sake of domestic producers, thereby nullifying a tariff concession that the country has negotiated at an international forum. Therefore, by virtue of an interplay of the state trading enterprises, the domestic monopoly could not be made to exercise rights which may adversely affect the tariff concessions that have been negotiated by the country. This article further can be linked to Article 2 Clause 4 of the GATT agreement, which deals with tariff concessions. And one may state that Article 2 continues to apply to import monopolies whether or not they are state enterprises. Now, this is further clarified in Article 17 Clause 4, which states that import monopolies on products which are not subject to Article 2 concession under GATT, and sets out that such monopolies shall on request inform the WTO members of the import markup on the product during a recent representative period or of the price charged at resale. Therefore, the interlinkages between Article 2 and Article 17 have further been clarified as per the terms of Article 17 Clause 4. Now, the clear purpose of these extra provisions relating to monopolies has been to preserve the value of negotiated tariff concessions, that is, to prevent an import monopoly from instituting protection for domestic producers and thus nullifying a tariff concession import markup which represents the margin by which the price charged by the import monopoly for the imported product exceeds the landed cost. Therefore, all these provisions, starting with non-discrimination and moving on to other aspects of a prohibition on quantitative restrictions and maintaining and valuing the tariff concessions, go on to state that even though a domestic monopoly is permissible under the realms of WTO, it still must not exceed or go beyond certain basic tenets of tariff concessions that have been negotiated and granted by the members. Now, moving on to the last aspect of transparency and how this obligation is imposed on the state trading enterprises. One may state that the reasons for notifications and the regime for making state trading enterprises more transparent is to make it possible for members to judge the extent to which state trading enterprises serve as a substitute of other measures covered by the general agreement. For example, quantitative restrictions, tariff and subsidies. Therefore, by virtue of notifications and making STEs more transparent, it also keeps a proper check and balance on the activities of these STEs and whether in the garb of a state trading enterprise it is not acting as a tool for violating provisions of the GATT agreement which otherwise are prohibited under other aspects such as quantitative restrictions, tariffs or subsidy regime. Now, the second rationale for enforcing a transparency provision under the state trading enterprise obligation is to allow the members to assess the possible trade distortions that may result from the operation of these notified STEs, and it is based on these trade distortions that certain actions can be conducted against the members. Now, we move on to the last aspect of the presentation dealing with the academic debate on whether the state trading enterprises rules are meant for enterprises or countries. Now, this debate has not been clarified as per the text of the state trading enterprise and the WTO provision, as the WTO provisions are silent in this regard. However, there is a brief note on the preparatory work and the negotiations that happened during the drafting of this provision in the agreement, which becomes relevant. During the drafting phase, a question was raised as to why Hungary made no notifications under Article 17 and what it considered to be a state trading enterprise, and the observation was made that at least foreign trading enterprises under administrative supervisions should qualify for notifications under Article 17. Now, there was a response from the Hungarian representative which stated as follows, that the trade pattern is usually shaped by the competitive position of firms. It is not decided or organized by the state, and thus the entity was not under any administrative supervision. Now, Article 17 therefore referred to state-owned enterprises or private enterprises having exclusive privileges in foreign trade, and not referred to enterprises and not referred to other enterprises which dealt with the work of other foreign countries. Therefore, it was clarified in this regard that the rules for STEs are mainly for enterprises and not for countries as a whole, and that too, the specific contour in which enterprises would be defined are the ones which are usually governed by the state or by private actors enjoying special monopoly, and not the ones which are foreign trading enterprises. Now, this issue was further not dealt with in the further negotiations, and the issue further died out during the Havana Charter negotiation, and therefore, in the current context of the WTO framework, the answer to this question is silent, but one may note that STE rules are usually applicable on enterprises and not countries as a large. With this, I conclude, and I would like to present a brief summary of the topics that we've touched upon in the course of today's presentation. We've looked into the meaning and type of state trading enterprises and the need that is felt to regulate the state trading enterprises. It's amply clear that the STEs could be made as a tool of disguised protectionism, and therefore there is a need to have a regulation in place. The regulatory framework of state trading enterprise has been defined and elaborated under Article 17 of the GATT agreement, and it deals with concepts such as exclusive or special privilege, commercial consideration, and the obligation of non-discrimination. We've further discussed the various types of obligations imposed on state trading enterprises in terms of a non-discrimination obligation restricted to MFN, transparency, and their obligation to preserve the value of tariff concessions. With this, I end my presentation. Thank you.